Okay, transportation engineering versus ANNETTE CRUZ and other parties. Whenever you're ready.
Good morning. May it please the court. My name is Daniel Rogers, and along with my partner David Johnson, we're from the law firm Shook, Hardy & Bacon, and we represent the appellant Transportation Engineering, Inc., also known sometimes as TEI or just the engineer. I'd like to reserve 7 minutes for rebuttal, please.
Okay.
Your Honors, we are here to correct the trial court's inconsistent application of the Slavin Doctrine. If that inconsistency is not corrected right now, the engineer TEI will suffer irreparable harm. Now, this court should hold that, consistent with Florida Supreme Court precedent in the Easterday case, that Slavin...
In the end, there was one order, correct?
There's an order on the clarified order.
Right.
There's one order that addresses the summary judgment for the contractor, the engineer, and the FDOT's immunity argument, yes.
Okay. And you understand that under our appeal jurisdiction, the part of the order that addresses your client is beyond our scope of review?
Under, yes, straight up appeal jurisdiction, we agree we're not allowed to appeal the denial of our summary judgment. But we are allowed to appeal the granting of a summary judgment of a co-defendant that would cause us harm.
And with respect to that, in order to obtain relief, you would have the unenviable position of having to demonstrate error by the trial judge with respect to that part of the order that we do have scope of review, which you haven't tried to do because you think that part was correct.
Right, yeah, and that part's correct. And Your Honor, at the end of the day, right, the rules and the Florida Supreme Court precedent say if you believe that there was an inconsistent application here, that we are suffering irreparable harm and there was a departure from the essential requirements of law, if you need to convert this into a certiorari petition pursuant to the rules, which is completely proper, then that's what's necessary because there needs to be relief now. And I don't think anybody disputes that this issue needs to be decided now because we're going to sustain irreparable harm if we don't resolve it.
What's the irreparable harm? I mean, you have a remedy on appeal.
We don't have a remedy on appeal. If you go through the hypothetical scenario where we don't appeal at the present time, okay, so then there becomes a final determination in this record that the contractor had no duty, did not breach a legal duty, and that the contractor is out on Slavin. We don't have the right then to put them on the verdict form as a Fabre defendant. And so let's say there's an adverse judgment against my client, and they go ahead and they appeal, and we come before Your Honors, and we argue, Your Honors, we should have gotten summary judgment back then the same as the contractor. And then this court holds, no, actually, you're wrong. If you would have come and appealed to us at that time, we would have made the determination that the Slavin summary judgment was incorrect. But you know what? You didn't do that, so you can't raise that issue now. So we would be left at that point in time with a holding at this court that we're not entitled to Slavin, but that the contractor got out on Slavin, and then we had to go through a trial where we couldn't put the contractor on the verdict form even though Slavin didn't protect the contractor. So we will suffer irreparable harm in not being able to assign responsibility to the contractor if we didn't appeal right now and obtaining a ruling from this court regarding whether or not there was an inconsistent application of the Slavin Doctrine. Right? There is absolutely irreparable harm here, and notably, there is no response from the plaintiff or the contractor on that issue. They do note, as Judge Lawson noted, they note a couple of times you can't appeal the denial of your summary judgment straight up. But very importantly, they never deny that there's not irreparable harm if we don't appeal right now. And while they try to say that there's no inconsistency in the Slavin rule now, if you look back, and I went back last night and this morning and read the summary judgment hearing transcript and the hearing on the motion for clarification, plaintiffs' counsel themselves say, I think at least 3 times throughout those transcripts, that if Slavin protects the contractor, everybody is out, right? If the FDOT accepted this project with a patent defect, everybody else in the chain of causation is broken. The chain of causation from everybody else's alleged negligence is broken. And the only one that should be responsible is FDOT. So that's why we need a ruling right now on this issue. And we need this court to decide whether or not there was an inconsistent application of the Slavin doctrine. Now, we also obviously need this court to reverse the erroneous holding on clarification that there was no duty on behalf of a contractor to build something safe on the turnpike.
I guess they don't respond to your argument at all that that was never the basis for a motion for summary judgment, which it would be an error to grant summary judgment on an issue that wasn't raised in the motion.
Yeah, absolutely, Your Honor. And
that their expert, although their expert testified in deposition that your client was not negligent, didn't have a duty or breach of duty, they did testify that the contractor was breached of duty by not going to the Part 400, those regs, and getting that from your plans and installing the cushions, I guess.
Absolutely, Your Honor. There's 2 reasons in the record factually why there was evidence of a breach of a duty, so summary judgment on the issue was appropriate. As Your Honor noted, there was a discrepancy in the plan. The plans actually noted use of the standard indices, which would have required the crash cushions, and the contractor should have brought that issue to the attention of everybody. And in addition to that, what the plaintiff's expert testified about was that there was a breach of the duty in not doing an RFI, or request for information, or a supplemental agreement for the crash cushions that were required. Now, plaintiffs and the contractor latch onto this. They try to get around that failure to raise the duty issue in their motion for summary judgment by taking the position that a threshold part of every Slavin argument, or every Slavin defense, is that you first must decide whether or not that particular defendant asserting that affirmative defense was negligent. And respectfully, there's no case law that would support that interpretation, and I don't think that saves them from the failure for the DAB, the contractor in this case, for failing to raise the lack of the duty argument in their motion for summary judgment. Now, right, another thing that I think, just a couple more facts in the record that I think, amplify the points that have been made on that particular issue, is that we are not dealing with, a contractor here that, lacks experience, or is this their first time on the job. I mean, DAB has had well over 500 projects with FDOT. They've done, $1 billion worth of work and multiple, I think up to 20 guardrail projects. So this is a situation where the contractor should have known what they were doing, and they should have raised that issue. And so at the end of the day, we believe that the only analysis before this court should be whether or not the 2 elements of the Slavin element have been met as to both the contractor and the engineer, right? Was there acceptance at the time when there was a patent defect? The trial court's finding on that, Your Honor is correct, we believe was correct, is that there was a patent defect that was accepted by FDOT, and there not being crash cushions. And that would break the causal chain with respect to the contractor, and it also breaks the causal chain with respect to the engineer. And so therefore, we would ask that the court hold that the summary judgment on Slavin is affirmed, but with directions that the summary judgment, should have also been granted with respect to the engineer. And, if that message is not clear with respect to, the trial court on remand as to what's going on, then, maybe we need to go a little further, and this court maybe needs to issue a writ of certiorari to direct the trial court, because there's a clear departure from the central requirements of law here, and there's clear irreparable harm. There's a failure to follow binding Florida Supreme Court precedent in Easterday in this particular case. Now, the final point that's trying to be made in the answer briefs in this case is that simply by constructing this project according to the plans, that absolves the contractor of all responsibility. Well, respectfully, that argument fails both legally and factually. First, there's no law that's cited to this court to support the principle that a general contractor like this, on this type of project, is able to escape liability for creating a dangerous condition because they simply followed the plans. There's no law on that, and there shouldn't be any law on it, because as the trial court aptly noted, you could have plans that call for a spike sticking in the ground that would impale somebody coming across. And if a contractor built that, would they say, oh, I built according to the plans, therefore I wasn't negligent, I'm not responsible? Of course not. So there's no law that supports that. And in addition, the facts don't fit here, because their argument that they constructed pursuant to the plan fails, number one, as I noted earlier, because the plans did call for crash cushions, and there was an arguable inconsistency there as to whether they actually built per the plans, which arguably called for crash cushions. And second, that they should have gone further. As Your Honor aptly noted, plaintiff's own expert indicated that they should have done an RFI, they should have entered into a supplemental agreement for crash cushions. So we believe that there's no impediment to this court holding that the Slavin ruling was inconsistent and directing the trial court accordingly. Thank you.
We have about 9 minutes and 40 seconds left for rebuttal.
And may it please the Court, Angela Flowers on behalf of DAB Contractors. Also at council table is Arnold Ginsberg on behalf of the plaintiff, Annette CRUZ. I will be speaking briefly to the Slavin issue, and then I will turn the podium over to Mr. Ginsberg. From DAB's perspective, the only issue that this court needs to determine is whether or not summary judgment was properly entered in favor of DAB under the Slavin doctrine. In this particular case...
And nobody's arguing that it wasn't, apparently.
Correct. As I would like to point out as well.
It'd be hard to reverse on that basis when there's nobody has demonstrated trial court error as to that decision, correct?
Correct, Your Honor.
So you have an easy job today.
And I believe that may conclude all that I need to say, and that I have as well heard no opposition as to the correctness of the trial court's determination on Slavin. And for that reason, as to DAB, the summary judgment entered in its favor should be affirmed.
Thank you very much.
Thank you.
May it please the Court, Arnold Ginsberg on behalf of the plaintiff. Your Honors, would ask this Court to affirm the summary judgment appealed. There exists no inconsistency in the trial court's rulings.
Well, let me ask you this. If we determine that there was, wouldn't you agree that there's no way that TEI can remedy on direct appeal at the end the problem that's created by their inability to put DEB on the verdict form as a Fabre defendant? I mean, if...
I respectfully disagree, because going to the question the Court just asked, I have to presuppose the existence of a problem, and there's no problem because there's no inconsistency. And I cite the Court to...
Assuming that there was an inconsistency. I mean...
Assuming that there was an inconsistency...
We'll talk about whether there was next.
Assuming there was no inconsistency, I still think the summary judgment gets affirmed here, and I don't think there's irreparable...
Right, no question about that. If there's no inconsistency, we would have, I mean, nobody's arguing, nobody's demonstrated trial court error with respect to the entry of summary judgment for DEB.
Correct. Then then the question becomes...
Because nobody's arguing that there was any error.
Then the question, well, there is argument that there was error. The argument...
Not in granting summary judgment based on the Slavin doctrine. Everybody says...
Well, then we get to what is the Slavin doctrine that everybody is pointing to, as opposed to, look, as I view it, let's, assuming the no inconsistency for a second, right? You have to ignore the record, because the trial court said at 4109...
But I mean, I'm just talking procedurally. You dropped your cross appeal. They're arguing that Slavin was properly applied to the contractor, should have been equally applied to them. So if we didn't address that part of the order that dealt with their duty, and liability now, and they get all the way to the end and say, we should have gotten summary judgment way back then, and we say no, then they've been deprived of their opportunity to have the contractor on the verdict form as a Fabre defendant. But they can't really argue for that relief now because it's their position that the summary judgment was correct.
I understand that they can't argue
Okay.
for that relief now. I also understand that they think they have a significant problem with the procedural aspect of this case. I believe they have a significant problem with the facts of this case, no matter when they get to raise it, because the trial court, again, at 4109...
Get to the thing you want to talk about now. Go ahead.
Well, right, it's at the heart of the court's question, actually, because it's a hypothetical that the court's asking me, which is fine. I'll deal with hypotheticals all day, but first let's deal with the record. And the trial court says at 4109, TEI is a little bit different. They had to design the system. And that's where the trial court said...
But in Easterling, the Florida Supreme Court said that the Slavin doctrine applies equally to the designer and to the contractor. So if this was a patent defect that was
if I
turned
might,
over- Yeah.
in Slavin, they didn't say that.
I said, wasn't it Easterling was the name of the case?
Well, Easterling didn't even deal with that. But let's deal with Slavin for a moment, because that seems to
So
be the issue du jour. Slavin had one owner and one contractor. That was it. When the court determined that the defect, right, was latent, the court said, from a pure negligence tort theory, the negligence of the contractor, right, is not cut off by the acceptance by the owner, because it was latent to the owner. That's a simple one-on-one situation.
Right.
Presupposing everything there is negligence on the part of a contractor, or two contractors, or three contractors. Because if, in fact...
The only basis for the summary judgment motion was application of the Slavin doctrine. There was no...
No, respectfully, was Slavin. And the judge on clarification said, I'm not going to get into that, right? Slavin had a duty, and it was in negligence.
I saw the motion for clarification or something which sort of pointed out that if you grant summary judgment to them based on Slavin, it would be inconsistent with the denial of summary judgment on that issue. You argued 3 times to the trial judge.
Absolutely.
And said, you know, that's an inconsistent application of the law. I mean...
And we're here on the trial court's ruling, not on the basis of some of the arguments that may or may not have needed clarification. The trial court said, let's take care of this. Forget about Slavin. I'm going to enter an order that basically says, right, the motion for a DAB summary judgment is granted.
Yeah.
That's the order. The motion for TEI summary judgment is denied, and then enter the judgment accordingly. Slavin is...
say that the appellate court will be able to look at the transcript and determine what the basis for my ruling is. And I can't really hide it by not putting it in the order.
Almost like review is like de novo, right? If there's any basis upon which to affirm the trial court. So without getting into what de novo means, let's talk about what was before the trial court and why the trial court thought that they were a little bit different. The system that was to be designed without crash cushions because FDOT would not budget for them. We learned that from Shannon from the FDOT. We learned it from R 2053, 2054 of the record, exhibits 1 through 4, which showed the budgeting, which showed no budgeting for crash cushions. So what do we have? We have DAB's duty was to build according to the plans provided, not to test the system. The case begins and ends with the duties assumed, which are the duties assumed as is evidenced by Slavin, and duties assumed as is evidenced by Easterday, and duties assumed by all of the cases cited in Easterday, including...
Okay, so you understand in a professional negligence case, the law recognizes that the common person doesn't really understand the duties involved in engineering and construction, and so expert testimony is generally required in order to to
Absolutely.
ferret. So,
absolutely.
And here's the problem you have. Your expert testified that the design, well, didn't actually, only that the design was appropriate because it referenced the reg or whatever called for a crash cushion, but that the contractor built an inherently dangerous System, okay.
Let's use that.
Because it didn't include a crash cushion, that was the danger. And then your causation expert testified that if there had been a crash cushion, the death would not have occurred. And so you have the basis for liability testified to by your expert, and I don't see another one in the record, is the absence of a crash cushion.
The duties assumed by TEI was to build a system without crash cushions, because it was not
That
budgeted.
wasn't your theory of liability.
The theory of liability that
The theory of liability was that in order to be safe, it had to have a crash cushion. It didn't.
No, I think that the issue was that you could design out the crash cushions, because crash cushions were not the only way to handle, right, the openings on the system. And FDOT said there were other ways. We are not going to budget for crash cushions. And so they said, TEI, you design out crash cushions and give us a system, angled edge, which was actually what it was all about, right? And that...
But your expert didn't testify that the design was inherently dangerous. You accept that. I mean, your expert testified that the design was fine because it referenced the need for crash cushions, and that the construction was dangerous because it didn't include the crash cushions. I mean, that's the testimony from the expert.
Well, the construction could not have been dangerous because it did not include crash cushions, because they built...
Unfortunately, that's what your expert
Well, I
testified
understand,
to.
I understand that, but
Unfortunately,
but we're talking about what the expert Ramos said about DAB. I guess that's basic, or TEI, what, Ramos. Basically, right, the statement was they should have had a request for information. I think that's really where the issue was. And the request for information would have gone to the FDOT and said, do you know that this is dangerous because it was without crash cushions? Now, we know that you cannot have negligence in the abstract. You need proximate cause, or remote cause if we're talking about de novo review. So what would have happened, and the trial court recognized it, if they would have, TEI would have notified, or no, DAB would have notified FDOT that we are constructing this, and by the way, there are no crash cushions. It would have had to be a cause in fact of the ultimate injury. But the response from FDOT would have been, of course, we know there's no crash cushions, we're not budgeting.
Here's the problem I have. What it looks like you're really arguing is that once we realize that our theory of liability, as testified to by our only expert, is a problem based on the Slavin doctrine, you know, maybe we should have moved to stay the proceedings, to go find another expert, to come up with a different theory of liability so that we could present a different theory against DEI.
I will at least not disagree with the court for this reason, and this reason only. There's only one order before the court, right? Which is exactly the question whether the trial court was correct, right, in granting summary judgment in favor of DAB.
Well, if we exercise our cert jurisdiction because there is no adequate remedy on plenary appeal, then we're going to address the issue of whether they should have gotten out on summary judgment.
Two conflicting rules, respectfully. One, right, a trial on the merits is not irreparable harm. Every case
That
cites.
says normally you can get all the...
Oh, I agree. That's why there's a second point that I'm involved here with, and that is simple, right? A record that is silent on a dispositive point, you can't get summary judgment. So if the only issue here is, right, was it correct for DAB, right? You can't get to, was it incorrect for TEI? And the reason you can't is, this case is not over. We could do a lot of things. This is not a trial on the merits, this is a summary judgment. And we have every right, up until the time of trial, and that's discretionary with the court, if it gets that far, for the court to say, okay, you're right.
So tell me what your argument would be if summary judgment had been granted, if you were the appellant here and summary judgment had been granted on both.
Same argument as far as I'm concerned. The duties are, the trial court gave you a map at the transcript.
So you went to a summary judgment hearing, you had presented one,
Yeah,
a causation
proposed.
expert and a liability expert.
Correct.
The only testimony about duty and breach of duty was that there was a failure to have crash cushions in the design and failure to have crash cushions in the construction. The causation expert testifies that that would have prevented the injury. So I mean, you're set as to that theory, but if that's a patent defect, then you have a problem with Slavin. So how are you going to get around that if we decide that it's not a latent defect?
I don't think that that's where we are. The trial judge, right, gave us a roadmap and said, I've got two summary judgments here, right? DAB, right, did not have to design the system, right? So
You're right. What the trial judge was saying is there may be another theory of liability with respect to the design firm that hasn't been presented. I mean, that's certainly
So he denied the motion for the TEI, but that doesn't necessarily mean here I have to explain on a silent record what we would do or what we would not do if there's an affirmance, right? And I don't think it's irreparable harm, right? Because we don't know what's going to happen, right? Right now, there's only an affirmance as to DAB, for all the reasons that everybody seems to be not challenging DAB. They didn't have the duty to test, right?
Part of his argument on the irreparable harm and not being able to have an adequate remedy on appeal is that because of the inconsistency in the motions for summary judgment, that he does not have the ability to bring in DAB as the Fabre defendant at trial, and therefore that's gone, and he loses it, and now does not have the opportunity to appeal that.
I don't disagree, right? But one has to go back again to what was the duty that somebody, you can't have Slavin, and you don't reach patent versus latent, right, without having negligence. I mean, that's the underlying cause, underlying basis for Slavin, negligence. You need to have negligence, you need to have a duty. If there was no duty, right, on the part of DAB...
Not to construct a dangerous condition.
No, they had to, DAB had to build the system according to the plans and specification. Let me deal with one statement, right?
Your expert testified that they built an inherently dangerous system. And now you're saying there's no duty? I mean, this is...
No, DAB had, look, the expert could have been right, the expert could have been wrong. The question is whether the trial court was correct on one issue, granting DAB's motion for summary judgment. The trial court denied the other one for a lot of reasons. And the trial court said, let's just take...
Recognize that the trial judge could not have granted summary judgment for DAB on an issue that was never raised in the only issue raised in the motion for summary judgment was
I am
Slavin.
totally at odds with that analysis completely. Because this court, if this court looks at Slavin, this court says, oh, Slavin only deals with, the Slavin rule only means latent versus patent. We don't get to negligence, we don't get to duty, we don't get to breach of duty, we don't get to the exact words in Slavin that says...
Because there was an issue of disputed material fact with respect to the duty issues.
In where? Slavin?
Underlying this case, and the facts of this case, they couldn't come in for summary judgment and say, here, we don't have a duty, because they were faced with your expert's opinion that they had breached a duty by creating an inherently negligent system. I mean, an inherently dangerous system.
As to DAB, we understand that they had no duty to test the system. So they were out. There was no duty, there was no negligence, right? They didn't breach anything. Interestingly, and this is, I want to comment, if I can, on the statement, and I'll end with this. TEI writes at page 3 of its reply brief, and I think this is the heart of the matter, that the engineer, TEI, and contractor had different contractual duties to FDOT does not mean they had different common law duties to third parties exposed to the allegedly dangerous condition. That is 100% incorrect. While they both had a common law duty to perform the contractual obligations non-negligently, DAB had no duty, common law or otherwise, to test the system. Its duty was to build according to the plan. And interestingly, you go right back to slavery.
To their point, where is the case that says that you can build an inherently dangerous system and you have no liability as long as it was built according to somebody else's plan?
It goes back to basic tenets of negligence. You have to have a duty, right? And absent that duty, right, there can be no negligence. Absent the duty, there can be no breach, right? So absent the duty, absent the breach, absent negligence, you don't get to the question of responsibility on their part for a latent or patent defect. And I don't agree that it's a patent defect, because the system was untested, the angled opening was untested, right? And that's the question of fact for the trier of fact, whether they were negligent in designing the system. And so DAB is correctly out, and I understand the questions from the court regarding, right, the expert this and the expert that, but at this point in time, DAB had no obligation, right, and that motion was properly granted, and TEI, who is different, and according to the trial court who said so, their obligations and duties were different, right, and I'm not reaching the question of negligence, right, their motion is denied.
You're about a minute over time. Thank you very much.
Thank you.
Your Honor, I think you got it exactly right. I mean, this is a situation where plaintiffs walked into a Slavin problem because of the expert opinions that they basically put forward through their expert. And now they're scrambling to try to save any aspect of their case that they can. I think they realize, man, the contractor's gone, but the trial court kind of threw me a bone and left the engineer in the case. Let me see whatever I can try to do. Let me throw duty against the wall. Let me throw proximate cause against the wall. Let me try to argue that there is no inconsistency, even though trial counsel said multiple times below that there was an inconsistency. I mean, here I'm reading on page 10 from the transcript of the hearing on the motion for clarification, plaintiff counsel. Judge, if I may, the order that you signed has an inherent inconsistency, and that inconsistency is the Slavin case. Because in the Slavin case, you remember the issue was whether or not this dangerous defect was latent or patent. Basically, if the DOT accepted this job as completed with an obvious latent dangerous defect, then not only should the contractor be let out, but we think the engineer. And that's exactly what we're here arguing, exactly what they conceded below. We have a situation here where there is an inconsistency. We also know that that inconsistency, according to our Florida Supreme Court, in the Easterday case, is a departure from the essential requirements of law. Florida law clearly protects everybody. Plaintiff's counsel keeps coming back to this idea that DAB had no duty to test the system, but as the court is aptly noted, that's contradicted by their own expert. And in addition, we know from the McCain case, the seminal case from the Florida Supreme Court, that duties can arise based on the facts and circumstances of the case. Here we've got facts and circumstances of creating an allegedly dangerous condition that their own experts said was a dangerous condition, and so therefore they had a duty under these circumstances. During oral argument, we heard again the idea that the absence of the crash cushions was not really the defect that's going on in this case. What plaintiff's counsel is actually doing is running headlong into the own case law that he cites in his answer brief. At the end of his answer brief, he cites the court to the black letter law that you cannot overcome summary judgment with merely paper issues. That's exactly what plaintiff's counsel are trying to do on appeal. Right? And that's what they were trying to do in their motion for clarification. They were trying to create a paper issue of this deflective design to try to overcome the clear summary judgment to which the contractor and the engineer were entitled. But as Judge Lawson, you aptly noted, and as we string cite in our reply brief in footnote 1 on page 2, all of the interrogatories, all of the expert opinions, all of the evidence, not the paper issues, but the evidence in the case, is about the absence of crash cushions. That defect was open and obvious that it didn't have crash cushions. That defect protects both the contractor and the engineer. We both should have been let out of this case. All of the tipsy coachman arguments that they're trying to raise are improper on this record. Either they were never raised below, or if they were raised below, they're contradicted by both the law and the facts. Because we will sustain irreparable harm if this departure from the essential requirements of the law is not remedied now, we respectfully ask your honors to enter a holding that summary judgment on Slavin was inconsistent, and with directions to the trial court to properly apply Slavin pursuant to Easter Day. Thank you.
Thank you very much. Thank you both. Okay, next case on the docket is